Resuming debate, reprise du débat, the Honourable Member for South Okanagan, West Kootenay.
Well, thank you, Mr. Speaker. And I'm happy to rise tonight to speak to Bill C-88, an act to amend the Mackenzie Valley Resource Management Act and the Canada Petroleum Resources Act. And as I said in my first speech on this bill, the overall position of the NDP on this bill is that Northerners know best how to manage their own resources. And we supported this bill at second reading, and we will support it again at the final vote, but feel that there were some opportunities in committee that were lost to improve parts of it. There's a lot of history to this bill and the measures taken over the years to bring more democracy to the North and end the colonial style of government that has been in place since Confederation. It seems, though, that every step forward has a few steps back, and this bill is perhaps no exception. It's a bit of an omnibus bill. It sets out to do two very different things. First, it would repeal parts of Bill C-15, the Northwest Territories Devolution Act, which was passed in the last Parliament. And second, it would bring into force an announced moratorium on oil and gas exploration and development in offshore waters of the Canadian Arctic. Bill C-15, passed in 2014, was also a bit of an omnibus bill in that it was two things. The bulk of that bill dealt with the devolution of powers from the federal government to the territorial government. The general public opinion in the North was this was, as Martha Stewart would say, a good thing. However, the second part of Bill C-15 went back on that, eliminating 4 regional land and water boards and replacing them with a single super board. And the feeling was that this was not a good thing. Those 4 boards were originally created out of land claims agreements and negotiations with various First Nations in the Mackenzie Valley area, and the new super board significantly reduced the input that those First Nations would have on resource management decisions. And in passing, I'll note that the previous Conservative government did similar things to the Yukon, so that the present federal government had to remove contested reforms to the Yukon Environment and Socioeconomic Assessment Act litigated by Yukon First Nations. And this led to Bill C-17, which rescinded those contested reforms in 2017. But back to the Northwest Territories and a brief list of modern agreements and treaties. And there's a few smaller ones that I won't mention, and the member from Northwest Territories has told me that there are 10 more that are in the process of negotiation as well, but I'll just mention 4 here. First, the Inuvialuit Agreement covers the northern part of the Mackenzie Delta, the Beaufort Sea, and the Northwest Territories portion of the Arctic archipelago. That region is outside of the areas covered in the regional land and water boards covered in Bill C-88, but it does bear on the second part of the offshore and gas exploration part of this bill. Second, the Gwich'in Agreement covers the southern portion of the Mackenzie Delta and the northern part of the Mackenzie Mountains. Third, the Saulteaux Dene and Métis Agreement covers the region around Great Bear Lake and the adjacent Mackenzie Mountains. And finally, the Tlicho Land Resources and Self-Government Agreement covers the area north of Great Slave Lake. These agreements are modern-day treaties that create and confirm Indigenous rights and are protected by Section 35 of the Constitution. The Gwich'in, Saulteaux, and Tlicho agreements contain provision for the creation of a system of co-management boards enacted by the Mackenzie Valley Resource Management Act. On each of these boards, there are 4 members and a chair. 2 of the 4 members are nominated or appointed by the Gwich'in, Saulteaux, or Tlicho, so that they have an equal partnership in those decisions. In parts of the Northwest Territories where there's no settled land claim, the main board created by the Mackenzie Valley Resource Management Act, the Mackenzie Valley Land and Water Board, is in operation. And in the Inuvialuit Settlement Region, the Canadian Environmental Assessment Agency conducts environmental assessments. This was all working well until the previous federal Conservative government came to power and was looking for ways to speed up resource development. It commissioned the McCrank report in 2007, which eventually put forward 2 options to streamline the assessment processes in the Northwest Territories, both of which would significantly affect the operations of the regional land and water boards. Option 1 was to eliminate the boards and replace them with a super board. The McCrank report warned that this option would take a long time to implement, as it would necessitate renegotiation of the land claims affected and a lot more consultation on top of that. Option 2 would keep the boards but reduce their mandates. Again, a lot of consultation needed, but perhaps not a full renegotiation of the treaties. In its habit of cutting corners and ignoring Indigenous rights, the Harper government picked option 1, but dropped the pesky renegotiation and consultation requirements, and then slipped that into Bill C-15, introduced in December 2013. Bill C-15 was primarily meant to implement the provisions in the Northwest Territories Land and Resources Devolution Agreement. However, as I mentioned, it contained this kind of poison pill in the form of changes to the Land and Water Co-Management Boards. And so that bill, the Harper bill, eliminated the regional boards in favor of a single super board consisting of 10 members and a chair. These changes were widely and wildly unpopular in the Northwest Territories and contrary to the wishes of Northerners. In committee, we heard from a number of witnesses about the negative effects of Bill C-15 and the legal battle that it unleashed. And I'd like to quote first directly from the testimony of Chief Alphonse Nitsiza of the Tlichon government. And he testified that the Wikiji Land and Water Board, that's the Tlichon board, and other boards in the Northwest Territories would be replaced with a single super board. Instead of appointing 50% of the board members, as our Tlichon agreement requires, the Tlichon government would appoint only 1 out of 11 members on this super board. The Mackenzie Valley Resource Management Act amendments could allow decisions about Wikiji to potentially be made by a panel of the super board that could lack Tlichon government appointees entirely. This was unacceptable to us. The Tlichon were promised something different in their treaty from what was designed in the Northwest Territories Devolution Act. The treaty promise was broken with no good reason, so we went to the courts for justice. The Tlichon government immediately sought an injunction from the Supreme Court of the Northwest Territories. That injunction was granted. It prevents the Mackenzie Valley Resource Management Act amendments from coming into force and remains in effect to this day. You should also know that the underlying lawsuit also remains active pending the results of this legislative process. The injunction will remain in effect until either a new law is passed, this one, I put in parentheses, or our lawsuit regarding the Northwest Territories Devolution Act runs its course, unquote. The Gwich'in representative at committee, David Wright, also mentioned the damage that even this temporary dissolution of regional boards would do to the regulatory capacity in the Northwest Territories. And again, I quote, "The injunction says the Tlichon in particular, because they were the primary litigant in this case, would suffer irreparable harm if those amendments were brought into force, because what it would mean was that the Tlichon, Satu, and Gwich'in land and water boards would be dismantled. Picture staff being sent packing, corporate memory and resources and capacity being disbanded, and the single Mackenzie Valley Land and Water Board being created. The irreparable harm is at that institutional bureaucratic capacity level, and it would take a lot to get that engine going again if the court result was ultimately favorable and was in line with the findings of Justice Shaner, I believe, in the injunction case. In other words, depending on what level of court this stopped at, if the result was yes, indeed, that this is an unconstitutional set of amendments that go against land claim agreements, then you would have to restart those boards years from now, which would just be lost time and waste and uncertainty," unquote. We also heard from Bob McLeod, the Premier of Northwest Territories, regarding the need for timely passage of Bill C-88. The government, and this is what the Premier said, "The government of the Northwest Territories supports swift passage of Bill C-88. The implications of not proceeding with the bill within the lifetime of this government and retaining the status quo are significant. Amendments to the MVRMA have been on the books for 5 years, and we don't want any more uncertainty associated with our regulatory regime. Resource developers are contemplating investing in developing the Northwest Territories' rich natural resources, and everyone benefits from regulatory certainty," unquote. So here we are with C-88 before us. And part of this bill is what the Northwest Territory wants. They want the devolution of powers. They want to keep the regional boards. But there's a part two. As I say, this is kind of a mini omnibus bill. And I'll now go to the second part of Bill C-88, which deals with the Canada Petroleum Resources Act. And this began back in late 2016 when the Prime Minister was meeting with President Barack Obama, and they both gave what was called the United States-Canada Joint Arctic Leaders Statement. In that, President Obama said that the U.S. is designating the vast majority of U.S. waters in the Chukchi and Beaufort Seas as indefinitely off-limits to offshore oil and gas leasing. At the same time, it seemed that Canada felt obliged to designate all Canadian waters as indefinitely off-limits to future offshore Arctic oil and gas licensing, to be reviewed every 5 years through a climate and marine science-based life cycle assessment. The Prime Minister made this decision without properly consulting any form of government in the North. He gave everybody a phone call 20 minutes before the fact. So Northwest Territories Premier Bob McLeod reacted by issuing a red alert, calling for an urgent national debate on the future of the Northwest Territories and saying that the Prime Minister's announcement was the re-emergence of colonialism. And a year later, in October 2017, I spoke to Dwayne Smith, who's the CEO of the Inuvialuit Regional Corporation. This was at the Generation Energy Forum meetings in Winnipeg. And he was, a year later, he was still hopping mad, very concerned about this issue. And I quote from a statement he made in 2016, and this is the quote: "There was a total lack of consultation prior to the imposition of the moratorium. This and the subsequent changes to key legislation impacting our marine areas are actions inconsistent with the way the Crown is required to engage with its Indigenous counterparts," unquote. And these concerns were again heard loud and clear at the committee testimony. Mervyn Grubin, the mayor of Tuktoyaktuk, said, "I just didn't want this to be seen again as another case of Ottawa throwing in this moratorium and showing us what to do. Do as I say, you know. That's what I didn't like. There was no negotiation. You just do this. Ottawa says if you do this, you do that." In response to the concerns of Northerners, Canada began a consultation process and agreed in October 2018, to begin talks with the territorial governments and the Inuvialuit Regional Corporation to reach a co-management and revenue sharing agreement. Meanwhile, current oil and gas development moratorium remains in place to be reviewed in 2021. And to wrap up, I'd like to comment briefly on the rushed timelines faced by this bill. You know, here we are in June 2019 debating a bill that everybody knew was coming back before the election in 2015. Consultations began on the Mackenzie Valley part of this bill right after the election, and if my understanding is correct, the consultations were largely finished by the summer of 2017. Yet this bill wasn't tabled until just before Christmas. It sat in limbo for 18 months. And I can speculate that maybe it was the decision to bring the oil and gas moratorium into the legislation that caused this delay. It needed more consultation. But whatever it was, here we are staring at the end of this parliament, in the face and risking the untimely death of this bill in the Senate. You know, when you have legislation that is literally being forced upon us by the courts, I think it behooves the government to move quickly, and that would have been to keep the two issues separate so the Mackenzie Valley Act could proceed first. And I'll finish by mentioning a couple of ways Bill C-88 could have been easily improved. We brought these forward, the NDP brought these forward as an amendment in committee, but were unsuccessful. The NDP is disappointed that the UN Declaration on the Rights of Indigenous People is not mentioned at all in this bill, despite the fact that of all the bills before us in this Parliament, C-88 seems to be the one most needing this reference. It's a bill dealing specifically with resource development, precipitated by a litigation brought forth by Indigenous people, pointing out with good reason that treaties had been broken, their views ignored, consultations not done. This Liberal government supported my colleague, the member from Abitibi, James Bay, Nunavut, EU, his private member's bill on putting the UN Declaration on the Rights of Indigenous Peoples into every appropriate legislation that the government produces. But there's no mention of that at all, nor the underlying concept of free, prior, and informed consent in this bill. And this was brought up in committee testimony as well. In its brief, the Northwest Territory Chamber of Commerce argues that the final decision to prohibit certain works and activities in the national interest needs to be approved by the Indigenous nation of the prescribed area, who are the stewards of the area, but also rely on the land to provide economic independence to their membership. In its brief, the Inuvialuit Regional Corporation said, further, while the Oceans Act and CPRA include non-derogation clauses, the requirement to consult with those who hold rights in marine areas is not clearly articulated. It's important to note that the imposition of the moratorium by the Prime Minister was done without consultation with any Inuvialuit in contravention of the Inuvialuit Final Agreement and with the framework established and the promises made under the Northwest Territories Land and Resources Devolution Agreement. The IRC adds the proposed Section 12(1) introduces national interest as a further basis for freezing licenses indefinitely. The national interest criterion is problematic as it elevates the national priorities of the day vis-a-vis Inuvialuit priorities within our traditional territory. David Wright of the Gwich'in suggested that if it could not be inserted into this bill, reference to the UN Declaration on the Rights of Indigenous Peoples should at least be seriously considered when the Mackenzie Valley Agreement itself is reviewed in the near future. And the second place that C-88 could be improved is through a real commitment for intervener funding in the review processes that this bill puts forward. While there is separate funding source available for Indigenous intervener funding in the North, it's not enshrined in legislation and it's not available for non-Indigenous groups. Intervener funding is included in Bill C-69 and it should be included in this bill as well. It's a critical part of any proper consultation. So to conclude, I'll just reiterate that the NDP will support this bill and hope to see it move quickly to royal assent before Parliament is dissolved. Thank you.
Questions and comments? Question et commentaires. The honourable member for St. John's East.
Thank you very much, Mr. Speaker. And I've been listening with some intent to the debate. We had a very interesting set of remarks from the member from Dauphin Swan River, Nepawa, and then, of course, some questions from the member from the Northwest Territories, and then perhaps a slightly backhanded support from the member of South Okanagan, West Kootenay for the bill. But I think what the debate may be missing is the sense that, and how many of us were elected in 2015 was on the sense that people didn't want a father's knows best approach to government any longer. And the top-down, unconstitutional approach is actually what was stalling our resource development and leading to so many injunctions against resource projects. And until the Conservatives take a long, hard look in the mirror, and perhaps I shouldn't say this because they might actually do it, and accept their failure on this file, they will stay on that side of the House for a long time. And so my question to the member from South Okanagan, West Kootenay, is do you feel that this bill will allow more resource development to happen in the North, or should we go back to the HARP reform?
The honourable member for South Okanagan, West Kootenay.
Well, I'd like to thank the member from St. John's East for the question. I know he's very attentive to resource issues across this country. I would just like to reiterate what he said. I think a lot of the failure to move forward on a lot of energy files, resource files over the last 10 years has been because the Conservative government has been really trying to rush these through, and by rushing them through, they cut corners, they don't do environmental assessments properly, they don't do consultation properly, and that has resulted in a lot of litigation in the courts on various issues. Unfortunately, it has continued with this Liberal government. We've seen the same thing happen with the Trans Mountain expansion project, where the consultation, so-called consultation done by the Liberal government was completely inadequate, and that put that project back for a year or so. So we have this, it seems like the rush to get these things through have resulted in actually none of them getting through, or very few. And so I would say that, you know, both the Liberals and Conservatives are to blame in this regard. With this bill, again, the first part, I think the NDP is very much in favor of the first part of this bill. It restores the 4 land and water management boards. It does what the Indigenous peoples and the people of the Northwest Territory want, and we're very much in favour of that.
Questions and comments? The honourable member for Kamloops Thompson Caribou.
And my colleague from the South Okanagan West Kootenay brought up truly what is the paradox of this bill. On the one hand, we have the Part A, which the government has put forward, they say, due to some lack of consultation and some movements made by the former Conservative government, for which they have many words to say about it. But then when you head into Part B of the bill, I would suggest that they have done more, that with less rationale in terms of lack of consultation, arbitrary move, creating moratoriums and a new concept in the national interest and government and council with no consultation. So I guess I would like my colleague to talk really about the paradox of what the government has done, and I also really appreciated his comments on the timelines and why with only a week and a half left, we are being told that we're stalling this bill that has not actually been presented for debate until the most recent past.
Honourable member for South Okanagan West Kootenay.
Oh, well, thank you, and I'd like to thank the member from Kamloops Thompson Caribou for that question. I would start with the last question or comment about the timeliness of this bill. Again, I could just reiterate that and we're seeing this with a number of bills that should have and probably could have been tabled before us a year ago or 2 years ago, but instead we're seeing right now at the very end of this Parliament and asked to rush through comments. We only had one committee meeting on this bill to hear from witnesses. I think it deserved more than that. Bill C-69 was the same. It was a very big omnibus bill itself. I think only 48 witnesses were heard at committee in that bill. This is where, when we end up relying on the Senate for sober second thought, I think it says a lot about the lack of work that we're doing here in this House. But to do that work, we have to get these bills before us in a timely manner, and I think that's unfortunate.
Questions and comments? The honourable member for Cowichan-Malahat-Langford.
Thank you, Mr. Speaker, and thanks to my colleague for South Okanagan West Kootenay on his speech on C-88. I was listening to the previous Conservative speaker talk about the Liberals and the NDPs and our position on various government bills in this Parliament, and I take real issue with some of his commentary on Bill C-68. I represent a coastal riding which is heavily dependent on wild salmon for its economy. And don't take my word for it, Mr. Speaker. Our opinion on C-68 was actually formed from people who have spent their entire lives working as fisheries biologists. Unanimous support in my riding for that. It is a rural riding, so I won't take any lessons from the Conservatives about C-68 and rural communities. I represent a rural community. It's on the coast. It is dealing with a resource, wild salmon, that directly affects the people who live in my riding. And, on C-88, I think the member for South Okanagan West Kootenay clearly elaborated to the House the testimony that we heard at committee from the people who are most directly affected by this legislation. And I listened with great interest to his comments, particularly about the timeline that this bill is facing, and that one First Nations group was saying, look, we're either going to go through the courts or we're going to rely on this piece of legislation. Given the mess that is happening in the other place right now, where we're going to have government bills coming back to the House with Senate amendments, some have been having trouble. Does he realistically think that C-88, with the timeline that we have left, is going to see royal assent? Or is this government going to actually have to entertain the thought of bringing the House back in the summer months? Is that how much importance they're going to have to attach to this bill?
The honourable member for South Okanagan West Kootenay.
Well, I'd like to thank the member from Cowichan-Malahat-Langford for those comments, and I agree with them. My riding is in the inside of British Columbia, the interior, where issues are different. We don't have that direct attachment to the sea, and yet my constituents tell me every day, they certainly told me during the election, that these environmental issues were very important, that things had to be done properly. They were dismayed at the Conservatives' gutting of environmental legislation, including navigation protection and the Fisheries Act, and the way the National Energy Board was conducting its hearings. So those were all things that got me energized in that last election. I'm a little disappointed, to say the least, at the slow pace that this Liberal government has been taking to turn that around. As to the timeline for this bill, I mean, what goes on in the Senate is fairly mysterious to me, and so I'm not going to comment on how rapidly this may or may not pass through the Senate, and I'll just leave it at that, Mr. Speaker.
Questions and comments? The honourable member for Northwest Territories. About a 45-second question. Hopefully we'll get a 45-second answer.
Thank you, Mr. Speaker. Mr. Speaker, in committee we heard quite a few presentations, and mostly ones that were favourable of Bill C-88, and we heard from the Premier stating that he was happy with negotiations on oversight and management of the Beaufort Sea, and things were going well. And they also, along with Grand Chief George Mackenzie from the Clean government, talked about how they needed to see this move forward through the legislative process and receive royal assent in this Parliament, and that the negative implications of the status quo are going to be significant. And if this bill is not passed, rising in June, Indigenous rights and other federal territorial initiatives, such as the 5-year review of devolution agreement, will be compromised. So I want to ask him, do you agree with the Premier and the Grand Chief that the negative implications of the status quo are significant?
For South Okanagan, West Kootenay.
Well, yeah, thank you to the member from Northwest Territories for that question and comment. And I totally agree that we need to pass this legislation quickly. The part that affects the Mackenzie Valley in particular is attached to a timeline of litigation. We're in an injunction situation right now. If we don't pass this, that litigation will start up again and continue. If a new government is elected in the fall, they may well appeal this, and we'll be in this endless cycle of litigation. I think it's really incumbent on us to pass this quickly. My comment to him is we could have, if they had tabled this legislation back in the fall of 2017, been done with this legislation and everybody would be working on other things. But instead we're here in June 2019 facing the end of Parliament, and this is the result of that. I think it has to be passed, and I hope it will.
Resume.